Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who've been geeking out with us for a while now, you know we have spent way too much time talking about the ATF's sudden reversal of course as it relates to force reset triggers, wide open triggers, and solvent traps. That, of course, led to Operation Reticent Recall, which, of course, then led to a bunch of nasty letters, which, of course, then led to a bunch of nasty visits from ATF, in which many of you had to surrender items which you had lawfully purchased. Well, as a follow-up to that, it appears that some of you who did that are now getting additional correspondence from ATF. And I think it's an opportunity for all of us to geek out together here and see if we can come to a consensus about what this really is. So, I'm going to need everyone's help today because we're going to talk about a truce or a trap, ATF's correspondence with those they seize triggers from. Okay, before we get going down the road we are going down, super excited about today's sponsor, Masterworks. Listen, in these uncertain economic times, we are all looking for different ways to diversify our portfolios. But have you ever thought about fine art? Well, founded in 2017 by a top art collector and tech entrepreneurs, Masterworks is the platform you need to get invested in fine art. Listen, the huge accounting firm of Deloitte projects that the current value of art worldwide is $1.7 trillion. But they also project that value to increase by the year 2026 to $2.6 trillion, or a whopping $900 billion appreciation over the next 4 years. Now listen, anyone who's been following this for a while should not be surprised, as art has outperformed the S&P 500 by a whopping 164% since 1995. Masterworks has sold 5 pieces of art since 2017, netting a return of 26.8% to their investors. Listen, during times of inflation, not like that would ever happen, right? Art has remained a valued investment, one that hedges itself well against inflation. Now, listen, remember, past performances are not guarantees to future success, but it is a pretty good indicator. Most importantly, Masterworks is democratizing the art world, allowing everyone to invest in a commodity once only reserved for the uber wealthy. Listen, you can buy and sell shares, so you don't have to wait for the artwork itself to get liquidated. You can sell your shares of an artwork on a secondary market. So visit them at masterworks.com and learn more. Sign up today and get your portfolio diversified using a commodity that was once only reserved for the world's most wealthy. Visit them again at masterworks.com. Okay, so the issue we're talking about today is yet another chapter in a very long and sordid saga of force reset triggers, wide open triggers, and solvent traps. Now, we're not going to go back and rehash everything all over again, but as we know, after ATF reversed course on this, they began Operation Reticent Recall, which meant they sent a bunch of nasty little letters to people saying, hey, you may be in violation of federal law, we need to talk to you. Those of you who did have communication with the ATF, either on your own or through me or through other counsel, learned that you essentially had a couple of choices, which is destroy your property, turn your property over to ATF, or face potential criminal prosecution. Now, I want to thank one of our loyal viewers, BW is what we're going to be calling, and BW lives out in the Midwest, and he got to me at a time when he had already received a nasty little letter from ATF. They were already hot to trot on him, and they wanted his forced reset trigger. Now, we did make arrangements to surrender that trigger, and that was done. And it went exactly according to plan, exactly the way we asked ATF to conduct the surrender. Everything went as smooth as humanly possible. Compliments to the local agent who helped us with that surrender. However, BW has since received a rather interesting letter from ATF, and I want to share that with you. And as you can see, I've highlighted a lot of it here, and we're going to be going through this because I'm trying to figure out if this is a truce or a trap, okay? And let me explain to you what I mean. All right, now, we know that there is a case, for those of you who've been geeking out, I did this video right here, okay? And if you haven't seen this video, I encourage you to watch it, okay? Because it's really, really important information, especially as it relates to Operation Reticent Recall. Because the case of McCutcheon versus the United States is a bump stock case. I know you're all rolling your eyes. Why the hell are we talking about bump stock? It is not a challenge under the Second Amendment as to whether or not bump stocks can be deemed unlawful. It is not a challenge under any of those grounds. That challenge has taken place multiple places, multiple venues, and has failed multiple occasions. Okay, this is a different challenge. What this challenge is it's under the Fifth Amendment takings clause. Okay, and in a nutshell, what the Fifth Amendment, the due process takings clause says is, listen, if government seizes private property from you, they have to give you just compensation for what they've taken. Now, what McCutcheon's claiming in this bump stock case is, hey, listen, okay, fine. ATF determines that bump stocks are illegal. They make them overnight. They make us all criminals, right? And that's exactly what they did with bump stocks. There was no grandfathering in of these or anything like that. It was overnight, boom, they are illegal. Either you destroy them, turn them into the government, or face criminal prosecution. So most people just dispossess themselves of the bump stocks. They either cut them up or they surrendered them to the government. But you see, they had money invested in these bump stocks, and when they purchased them, they were absolutely 100% legal when they purchased them. Sound familiar? Like, I don't know, forced reset triggers, solvent traps, wide open triggers, hellfire trigger systems, anything of the such, okay? So what McCutcheon's saying is, hey, fine, you dispossessed me of the bump stock, that's cool. But the government owes me the fair market value for the property that they took from me. And that is how the constitutional takings clause works in the Fifth Amendment. Check that video out. We geek out about it a lot more. So the document that BW received, and I think a lot of other of you are going to be receiving this, is Notice of Seizure of Property and Initiation of Administrative Forfeiture Proceedings, okay? This is government's way of saying we now have property and we are going to officially commence forfeiture proceedings. Now, I want you to pay very careful attention, though, because what they are claiming the forfeiture is done, and this is per the actual letter, it states as follows: the forfeiture of this property has been initiated pursuant to 26 United States Code Section 5872. Okay, so what does that law say? Well, when we look, that statute tells us any firearm involved in any violation of the provisions of this chapter shall be subject to seizure and forfeiture, and, except as provided in subsection B, all the provisions of the Internal Revenue laws relating to searches, seizures, and forfeitures of unstamped articles are extended to and made to apply to the articles taxed under this chapter and the persons whom this chapter applies. So understand that they are claiming that this forfeiture was because you had an unlawful item that should have been taxed, like a $200 tax stamp, and was not done so. What was it? It was a machine gun. How did you possibly own a machine gun? Well, you owned a forced reset trigger. Now, this document gives BW and anyone else similarly situated two options. Number one is you can protest the forfeiture of the item itself, or you can require that you be compensated for the item that was taken to you. Wow, that sounds an awful lot like a truce. Is it the ATF actually realizing, like, boy, you know, these McCutcheon folks over here in this other case sitting down waiting to review before the United States Supreme Court, they got a pretty good point here. I mean, we did take those bump stocks from everybody, and man, that's going to have a pretty hefty price tag on it. Should we possibly do the accounting and bookkeeping for this ahead of time? That is one possibility. Now, I know many of you are rolling your eyes, spitting out your coffee, and laughing hysterically at that suggestion, but that is a possibility. I'm not suggesting there's a high probability to it. I'm suggesting it's a possibility. But is there something more nefarious going on here? Because I want you to pay attention to some of the instructions that they gave BW right away. C. Requirements for petition. The petition must include a description of your interest in the property, supported by documentation and any facts you believe justify the return of the property, and be signed under oath, subject to the penalty of perjury, or meet the requirements of an unsworn statement under penalty of perjury. Okay. So you have to make a statement as to what your ownership interest was in the item and why you believe you deserve it back. But wait, there's more, because the other instructions tell you. E. Supporting evidence. Although not required, you may submit supporting evidence, for example, title paperwork or bank records showing your interest in the seized property to substantiate your petition. F. No attorney required. You do not need an attorney to file a petition. You may, however, hire an attorney to represent you in filing a petition. I. Penalties for filing false or frivolous petitions. A petition containing false information may subject the petitioner to criminal prosecution under 18 U.S.C. Section 1001 and 18 U.S.C. Section 1621. And then listen, if you are asking for financial compensation for the property that was taken from you, they are requiring a significant amount of financial disclosure. Now, this is disclosing your financial records to the Department of Justice, okay? Have you received any income from business professions or other forms of self-employment, rent benefits, or anything of that? Dividends, things like that. Do you owe any cash, checking accounts, savings accounts? And then please state the total amount in each of those accounts. Do you own any real estate, stocks, bonds, automobiles, or other valued personal property? So these are the types of questions that they're asking you. But then here's the real hook. And this is the thing I want everyone to be aware of. Because the other thing, if you're saying, hey, I have a property interest in this, and therefore you either owe me my property back, or you owe me the fair market value of the property you took. This is what Department of Justice is also asking for. On the seized asset claim form, list the items in which you claim an interest. Include sufficient information to identify each item, such as make, model, and serial numbers, tail numbers, photographs, and so forth. Additional space is provided on the back of the form. You may attach additional sheets of paper if more space is needed. And then in addition to that, in Part 2, the claim form asks, state your interest in each item of property listed above. Please provide any documents that support your claim of interest in these items. Supporting documentation includes titles, registration, bills of sales, receipts, etc. Okay, and then in the final instructions, BW is told that he has 30 days from the receipt of this notice to file a claim if he so desires. He also has to post a surety bond, and this is actually what the instructions state on that. Cost bond. The claim must be accompanied by a cost bond in the amount of $5,000 or 10% of the value of the claimed property, whichever is lower, but not less than $250, made payable to ATF. And then, of course, there is ways for those that are indigent to go through waiving that. Now, I'm going to assume that the average value of one of these triggers was approximately $400 retail value. 10% of that would be $40, but the floor set by the rule here is $250. So BW, if he wanted to submit this paperwork, will have to spend $250 for the privilege of having Department of Justice dissect his entire personal life. Okay. Then on the claim for remission or mitigation, in addition to wanting you to establish, obviously, that you have an interest in the property, I want you to pay careful attention to what they're asking here. Describe your interest in each item of property as owner, lien holder, or otherwise for which you seek remission or mitigation of forfeiture. Please provide any documents that support your petition for each item. Supporting documentation includes original or certified bills of sale, title, registration, receipts, etc. And there is another terminology for everything that they are requiring, which is evidence. You see, because what many people have been concerned about, as I spoke to many of you around the country, is hey, ATF appears to be playing pretty straight up with these triggers and these traps. However, are they going to circle back on me someday and say, aha, we now can prove ownership or provenance in that item, and we now want to prosecute you for unlawful possession? When you take a look at the information that they are asking and the inability for many of them to truly connect the dot from point of sale to purchaser, what you do by filling out this claim is you fill in all the blanks. They have a story that has the bookends to it. They don't have the middle of it. And what these documents are asking from you, the lawful and responsible gun owner, is for you to fill all the gaps in for them, to assist in many ways in potentially your own prosecution. Now, what happens if you don't fill out one of these forms? Well, your item is going to be forfeited and you will be dispossessed of it and you will receive no compensation. Is this $400 hill the hill that you want to die on? I leave that to all of you, the lawful and responsible gun owner. However, when we take a look at the potential benefit that we may receive if these claims are really being done on the up and up, that is that the ATF in some sort of benevolent fashion has seen the tea leaves here as it relates to McCutcheon versus United States and realizes, oh my gosh, we've taken all of these triggers and traps from people and we're going to have to compensate them. Otherwise, it's going to end up in the United States Supreme Court. That is one point of view. The other point of view is that the ATF has been so weaponized that they are out to get many lawful and responsible gun owners. And this request to contest the forfeiture is actually a method by which they gather all the necessary evidence to prosecute you. So what I want to know from all of you in the comment section below is, do you think this is a truce? Do you think it's a trap? If you received a letter, let us know and let us know what you intend on doing. My advice to BW is probably going to be like, I'm not sure this is the hill worth dying on. We're probably going to let this one slide, but that's between me and him. Listen, in the meantime, if you have any other questions about this or anything else related to your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.